On this episode of Law Weekly, we look again at the Petroleum Industry Act and the move by the President seeking some amendments to the legislation. We have the views of an oil and gas expert, Aderemi Fagbemi. Also showing on the program today, Lagos State addresses issues of land grabbers, educates residents of Ekpe and Ibeju-Lekki communities on the state's property protection law, plus a recap of some of the top trending legal stories. Hello and welcome to the program. I'm Shola Shieli. It was on Tuesday, September 21st, that President Muhammadu Buhari wrote to the National Assembly seeking amendments to the Petroleum Industry Act. This move is coming less than 2 months after the President signed the bill into law. And this has raised questions and concerns about whether the bill was properly scrutinized before it was passed and whether this will stall its implementation. My guest on the show today is an energy and natural resources expert with experience spanning about 2 decades. Aderemi Fagbemi has been recognized by leading ranking firms such as Chambers and Partners Global and IFLR 1000 as a leading lawyer in the energy and resources industry. She's been involved in the development of legal, regulatory and policy framework documents in the oil, gas and power sectors. And she agrees that someone dropped the ball with scrutinizing the PIA as passed.
When I heard about it on the news a couple of days ago, I smiled to myself. I was like, what? So soon? When a lot of people are still even reviewing and trying to understand and grapple with the provisions of the act. But yes, as to whether the president has the right or the powers to ask for an amendment of the act, just
weeks after
he had assented to it. The very simple and direct answer to that is yes.
Okay.
It's not a power. It's actually a right he has as another stakeholder, just any other Nigerian citizen, actually any other stakeholder. So he is not going to be, demanding.
Okay.
He's just going to be appealing to the National Assembly.
More like lobbying them.
Yes, basically. And if the National Assembly see reason why they should be making that amendment, yes, he can make it. As we're aware, the Constitution by Section 4, grants or vests the legislative powers, of the country in the National Assembly, and goes further to say that the National Assembly, which is the Senate and the House of Representatives, can pass a bill which the president will then assent to. There's nothing directly, no provision directly in the Constitution that talks about amendment. But if you look at the Interpretation Act, Section 10 to thereabout, I think it basically says that where an enactment has vested a right or permits someone to carry out a right, then it is assumed that every other thing for that act, to be properly executed, as it were. It's assumed that those rights are also given to that body. So basically, the National Assembly, just as like any other time, has the right to make laws and to amend those laws. And so if the president is appealing to them to amend the laws, if they see reason why they should, that's the Senate and the House of Assembly, then that can be done. With regards to whether it will stall the process, he shouldn't. The PIA is an act as it is right now.
Okay. So
things should go on as they should. And I actually think it was because the president was trying to actually start to kickstart the process of enforcement, by appointing certain people that he realized, as it were, that certain provisions need to be changed. And so, yes, it's legal.
Have we been down this road before? There's an assent given and then we ask for amendments after. Has it ever happened?
I do not recall any such. Nothing comes to mind. But, yeah, it's unusual. It's irregular, but it's legal.
It's legal.
Yeah.
Okay, there was also something that you said about is like any stakeholder, seeking an amendment. So does that mean that any other stakeholder can also ask for an amendment?
So the thing is, right now, the PIA is just an act like any other act. So it doesn't matter whether it's 2 days down the line that you're asking for an amendment or 20 years down the line. The point is, it's an act of the National Assembly. Stakeholders, interested parties can decide to seek for an amendment, but they will go through the regular channels and seek their amendment from the National Assembly. And the National Assembly is minded to consider it, then they will.
The amendment that is seeking, I see that it's an administrative one of membership, expansion of membership. And the president in his words said, because it has not addressed the principle of balanced geopolitical representation of the country. So he wants the intervention of the Ninth Assembly to correct this oversight in the interest of our national unity. So this expansion of membership, is it really necessary, this amendment, do you think?
He's looking for, the president that is, he's looking for an amendment with regards to membership of the board of the Nigerian national, the upstream regulator, basically. That is the Nigerian National Upstream Regulatory Commission.
Yes,
yeah?
Nigerian Upstream.
The Nigerian Upstream Regulatory Commission.
Yes.
And then he's also looking for the same kind of amendment to the composition of the board, yes, of the Nigerian Midstream and Downstream Regulatory Authority.
Yes.
They have similar provisions with regards to the composition of the board, and is seeking for an amendment. Now, the amendment basically, or should I say the provision of that, or, you know, of the commission, the board of the commission and the board of the authority, there is a particular provision, section 11 and section 34 respectively, that that seeks to appoint two non-executive members to the board of the commission, non-executive commissioners to be precise, to the board of the commission and the authority respectively. And so what the president is saying is those two non-executive commissioners should be increased to 6 in order to, you know, meet the requirements of a federal character, basically meet the, you know, cut across the 6 political zones of the country, which, yeah, is fine by itself. But my concern is that someone dropped the ball somewhere. This bill, the bill was passed, you know, was assented to by the president, like you said, merely 40 days ago. What happened? We've had previous versions of this bill where we had an interagency team set up by the executive, you know, reviewing the bill and submitting their opinion to the National Assembly for the National Assembly, you know, to look through before they even pass, you know, and before it goes to the president for assent. So I'm thinking what happened, you know. And the interesting thing about this is that, if you recall, in 2018, the Petroleum Industry Governance Bill was passed by the two houses of assembly, the Senate and the House of Assembly. I mean, the House of Reps, sorry. And it was just waiting for the president to assent. Now, a little history to the Petroleum Industry Governance Bill. At a point when, you know, there seemed to be a lot of hold-up with regards to passage of the PIB, we decided that maybe we need to break it down into different sections, and let's take it one at a time. Let's take a section, deal with it. When stakeholders are fine with it, we can pass it. And so they were able to achieve that with the Petroleum Industry Governance Bill, to the point of taking it to the president for assent, where it was stopped. Now, fast track down the line, this is 3 years down the line. Even though the president did not assent at that time, this bill was before the president, and I would think that the executive would have looked thoroughly at this bill. Because, guess what? The same provision with regards to the constitution, the two non-executive members, commissioners, that same provision was in the PIGB, you know, as of 2018. And so, at the very least, they might as well have looked at those provisions. And another thing that I read,
make sure that they tally.
Yes, that, you know, no, it was the same thing. So if they had an issue,
the same two members.
So if they had a problem with it at that time, they might as well have flagged it. So that
now.
Yeah, and then you have the president signing. It's a bit untidy for me. And then I'm not privy to the letter to the Senate, and one of the things that I hear that the president asked for is what you just said. I've also heard or read that the president also asked that the ex-official members, you know, in that in the composition of the board should not be, you know, once the president appoints them, there is no need, there should not be need for Senate assent, because they are already civil servants, as it were, you know. If that were the case, then it seems as if, should I say, the president or his team did not really understand or did not really go through the provisions of that bill, because that particular provision basically actually says, so the president has the power to appoint all the members of the board of the commission and the authority, and then the National Assembly would assent. But the provision actually says, except for certain sets of people. And these sets of people are the ones that are the ex-official members. They are the representatives from the Ministry of the Federal Ministry of Petroleum Resources, representative from the Ministry of Finance, and the representative of the authority on the commission and the representative of the commission on in the authority, you know. So those people, there is already a provision in the Act that says that they do not need the appointment of the president and the assent of the National Assembly.
So this amendment is not necessary?
This particular one I'm talking about, it doesn't seem, it's not necessary because they've been exempted as well. So if the president is asking for an exemption, then it seems as if someone is missing something somewhere. Okay. Yeah. I also read as well that they're asking for some reporters said they're asking that the ministers, the Minister of Petroleum Resources and the Minister of the
removal of the Ministries of Petroleum Resources and Finance from the boards of the two institutions.
Yeah. Okay, so if it's just the ministry, so representation. So what we have on the boards right now is representation from those ministries. Now, if that is what the president is talking about, yeah, to an extent, he has a point. One of the arguments that was canvassed was the fact that ministers have policy-making powers, and they have a portfolio with regards to policy, supervision, and government representation in international fora and all that, and that should be enough, and they don't have to be members of the boards of these agencies. Yeah, to an extent. But then again, like I said, in the old PIGB, this provision was there. Who missed it? And bear in mind that the minister is still supervising, to an extent, these agencies, and there are certain roles that he or she has to play in this, you know, in guiding the execution of the functions of these agencies. So if they need to have representations, why not? The only place that I would think that maybe the representation from the Ministry of Finance and the representation from the Ministry of Petroleum Resources may not be necessary with regards to the NNPC Limited. Because we're looking for a corporation that is, or should I say a company this time around, no longer a corporation, a company that is in step with times and that is a properly run profit-making entity with, you know, with less bureaucracy, as it were. So the less of political appointees we have on that board, the better for, yes. So I think that's the only place where I think it's probably necessary. But like I said again, these representations were there before. Someone dropped the ball somewhere, but here we have it. That's it.
What else? I know these are the areas that the president has put up for amendment, but as an oil and gas expert, what other areas do you think, now that we have an opportunity for an amendment, that we probably should be looking at?
$1 million question. I think, interestingly, even when the PIB was still ongoing, you know, when it was still a bill, you know, over the years, we've had different people, stakeholders, you know, raise different issues. You know, the PIB should have this, should not have this, should represent certain interests and all that. And I think the debate can go on forever. Rarely across the world would we get a perfect legislation. Rarely do we have that. But what do we have? I think the important thing is, first of all, I'm happy that it has passed finally. It may not be perfect for all stakeholders. It's difficult to satisfy everyone at the same time. But I think we have a bill or an act, as it were, that has tried to address certain issues and should be able to stand up to any other acts of its type.
Anywhere in the world. Anywhere
in the world. So having said that, I've had arguments being canvassed about the fact that this is the time for the president to also look into the arguments of the host communities that the trust fund that is to be set up, you know, based on the provisions of the act, should now be 5% rather than the 3% that we have in the PIA at the moment. Now the thing is that when the National Assembly passed the bill, you know, it's canvassed for 2.5%, you know, of the total annual expenditure, the previous year's annual expenditure of the operating entities, the licensees and lessees in the both upstream, midstream and downstream operations, you know. And then when the ad hoc committee gave their recommendation, they asked that the upstream operations should be 5% equity and then 2% for others, probably midstream as it were. Yeah. Now, the bill says 3%. Should it be 5%? Should it be 3%? This is not something that I can talk about. It is very political, yeah, and there are a lot of passion, interests involved in this. Sure. But what I would say is this: if the 3% is properly managed and utilized, I mean, it will bring about a lot of change that the communities are asking for, and nobody will be worried about the percentage, whether it's 2%, 3%, or 5%, or even more. I think what the host community should be looking forward to is seeing something happen. And I really do have faith that because the operating companies, the oil and gas operating companies, are going to be involved in this process, it's likely to have more success than, without going into details, other provisions that have been made for the development of those communities, and we should just wait and see.
Vice President Professor Yemi Osinbajo has asked the attorneys general in the country to leverage on their contacts and individual positions to effect the changes necessary for the justice sector. He said this when he received the 6 attorneys general from the southwest states who were led by the Ekiti State Attorney General Olawale Faponda. The delegation briefed the vice president on the progress of justice reforms in their various states, many of which they said were inspired by the successes recorded during his stint as Attorney General of Lagos State. While the vice president commended the attorneys general for the work done so far in ensuring reforms in the justice sector, he urged them to ensure prosecutions move quickly and devote some time to improve the pace of cases in courts, especially at the state level. In other news, the Lagos State Ministry of Justice has taken its campaign against the nefarious activities of land grabbers to the residents of Ekpe and Ibeju-Lekki communities. At a stakeholders meeting on the issue, the leadership of the ministry educated residents on the available laws and the rights of residents and communities.
Government officials, law enforcement officers, traditional rulers, elders, landowners and residents of Ekpe and Ibeju-Lekki communities are all gathered here for a stakeholders meeting on land grabbers, the law and your rights. The State Attorney General and Commissioner for Justice was represented at the event by the Director, Office of the Public Defender, and he told the gathering that the rise in cases of land grabbing in the state is giving the government a lot of concern as it continues to impact negatively on the growth of the real estate industry and investment.
There cannot be progress, there cannot be investment, there cannot be security, there cannot be good governance if there is no enabling environment for good ownership of land, and also to ensure that people who have title to land are also protected in terms of their investment in the land, probably for manufacturing, for development, for any other purpose to which the state has given them title for. So one cannot overemphasize the importance of this kind of meeting.
He explained some of the provisions of the Lagos State Property Protection Law 2016, and in particular Section 2(1) and Section 3 of the law, which prohibits the use of force to take over another's landed property, an offence which attracts a jail term of 10 years imprisonment.
As from the commencement of this law, a person or group of persons shall not use force or self-help to take over any landed property or engage in any inconsistent with the proprietary right of the owner. A person or group of persons who haven't used force to take over a landed property in the state before the commencement of this law and remain in possession of that law is liable also, and he has committed offense.
One of the traditional rulers present acknowledged the efforts of the state government at curbing land grabbing. He also noted that the community and the police have an important role to play in the Greater Lagos Initiative.
Our youths, we are the one encouraging them. They have become lazy and sloppy. They don't want to do anything. And as a result of that, some of us recruit them. We will keep our own children abroad. We put our own children in good schools. Some of us will recruit them to be doing land grabbing. And then you now give them peanuts. Rather than encouraging them to go and learn a trade, to go and do a job, to go and do something with their lives, they'll be doing land grabbing when there is no other thing for them to do. And then they give them all these guns and all these things. Forgetting that there is a law well laid out by the state government concerning property protection. They call it state property protection law. Am I right? Yes. That is in place. And that anybody that goes foul, I'm glad that the law enforcement officers who they are here today, anybody that runs foul of that, then there is always a penalty for it.
Other stakeholders also proffer solutions to dealing with the menace.
We are working tirelessly to seek the collaboration of all the agencies of government or the species or branches of MDAs that has issue with land matters to assist us in ensuring that all this issue is discouraged and is dealt with from the board.
We collaborate with that agency from our branch because we have a lot of problems of land grabbing. However, after doing or conducting their proceedings, you still find out that they come up with reports. What is the status of their report? They are just like toothless bulldog.
Special court is created. It will help in expediting action so that some cases that are taking so long before they are getting judgment will come to being and be executed on time. And so we have results. And so those that are supposed to be punished will be punished, and it will serve as deterrence to others.
And just before we go, let's bring you a recap of some of the legal stories that made the headlines.
We begin with the report that the Supreme Court has fixed November the 1st to begin definite hearing on applications in the suit seeking to stop the federal government from ceding 17 oil wells in Rivers State to Imo State. Rivers State had filed a suit against the federal government and the Imo State government seeking a declaration that the boundary between Rivers and Imo State as delineated on Nigeria Administrative Map and other maps bearing similar delineations are inaccurate and do not represent the legitimate boundaries between both states. The Apex Court had granted an interim injunction against the federal government pending the determination of the suit brought before it by the Rivers State government. At the hearing of the suit on Tuesday, September the 21st, a 7-man panel of justices, led by Justice Kekereekun, granted a motion filed by the Attorney General of the Federation for leave to regularize the court papers filed. The AGF has filed an application challenging the jurisdiction of the courts to hear the suit. Through his counsel, the AGF argued that the suit of the Rivers State government is instituted against actions of some federal government agencies and not the federal government itself, and as such, the Federal High Court is the best place to hear the suit. At the Federal High Court in Abuja, Justice Ahmed Mohammed has fixed November the 17th to hear all applications by the Economic and Financial Crimes Commission, the EFCC, the Attorney General of Imo State, and 48 others, challenging the jurisdiction of the court to hear a suit filed by the former governor of Imo State, Senator Rochas Okorocha, seeking to stop the state government from confiscating and demolishing his property. Justice Mohammed fixed the date after counsel to Okorocha, Mr. Oba Maduabuchi, told the court that his head of chambers had passed on. On August the 12th, the court declined the request of the former governor for an order to stop the EFCC and the Imo State governor from confiscating his property based on reports of various panels that investigated allegations of financial infractions he reportedly committed while in office. Another judge of the Federal High Court Abuja has fixed November the 30th for judgment in a suit filed by the post-emir of Kano, Lamido Sanusi, against the Kano State government and others. Justice Anwali Chikere fixed the date after counsel for the parties in the matter adopted their written addresses. In a motion ex parte dated March the 12th, 2020, the former emir had sought an interim order of the court releasing him from the detention and/or confinement of the respondent and restoring his right to human dignity and personal liberty. At the Lagos High Court, the chairman of the Economic and Financial Crimes Commission, Abdulrasheed Bawa, has testified about how an oil marketer, Abubakar Peters, and his company Nadabo Energy Limited forged documents to obtain the sum of 1.4 billion naira as subsidy from the federal government. The EFCC chairman, who was in the witness box for over 6 hours, gave extensive details of how the EFCC conducted its investigations and uncovered the fraud through the witness. The court also admitted in evidence several documents as proof of the alleged fraud. The case has been adjourned till November the 1st and 2nd this year for the cross-examination of the EFCC chairman. And we round off with a report that members of the Ogun State chapter of the Judiciary Staff Union of Nigeria have suspended the industrial action they embarked on over 2 months ago. The state chairman of the union, Tajuddin Edun, announced the suspension on Thursday after a meeting between his members and officials of the state government. He said that the series of meetings held by the striking union and officials of the state government culminated in the decision to suspend the industrial action, which has paralyzed activities at the various courts across the state since it commenced on the 11th of August. He also revealed that the government has accepted the demands of the workers, just as the workers have resolved to work with the government to take the state to greater heights.
And that's our program this week. Don't forget that you can find these and past episodes of the program on our YouTube page. I'm Shola Shayeli. Thank you for watching and see you next week.